and a separate event that led to the young man, the victim Jacoby's death in December of 2016. I'm also going to focus on the trial court's decision to admit as expert testimony Dr. Deering testifying about battered child syndrome, and in particular his decision to admit Dr. Deering's conclusion and autopsy report that listed as a contributory cause of death Jacoby's non-lethal prior injuries. He termed that multimodal trauma in the autopsy report. And finally, I'd like to address the trial court's answers to 2 supplemental jury questions that were asked during deliberations that had to do with what evidence the jury needed or could consider for each of the counts. And I will, of course, address any other questions that your honors have. But just to lay the background a little bit, Ms. Gardner.
The state concedes the last issue, right?
The state concedes that it did result in a failure of unanimity and undermine the integrity of the verdict. As to count 4, we would argue more broadly that it undermined the integrity of the verdict as a whole.
Okay.
But yes. Mrs. Gardner and her husband, Phillip, were originally charged with 1 count of felony murder based on an uncharged predicate offense of aggravated child abuse. After some pretrial motions had been heard and considered by the trial court, the state filed a superseding indictment that added 9 charges. We subsequently asked for severance, breaking those collectively 10 charges into 4 separate groups. The first set being the 2 counts of felony murder that are charged in the alternative, 1 based on aggravated child abuse, which was charged in count 3, and 1 based on aggravated child neglect that was charged in count 4. A set of aggravated child abuse and aggravated child neglect charges that had to do with a specific date of November 25th, 2016. Another set of aggravated child abuse and aggravated child neglect that had to do with a specific injury, and those dates more or less overlapped the entire period. And then finally, 2 aggravated child neglect counts that that allege the entire time period that the young man was in Tennessee for this particular visit. I think those dates are September 28th through December 7th. So again, we filed a motion to sever into those 4 sets of counts under Rule 14b1. When a defendant requests severance under that rule, the right is absolute unless the state can show that those sets make up a part of a common scheme or plan and that they would be admissible in the trial of the other, basically under Rule 404b. Here, the trial court specifically found that, well, the trial court granted partial severance. I'll start by saying that. It did find that the first 4 counts, that first set of felony murder with the underlying predicate offenses, could be 1 set. The second set would be the paired counts of aggravated child abuse and aggravated child neglect. The third set would be that second set of just those counts. And then the trial court ruled that because counts in the original indictment 9 and 10 charged aggravated child neglect as a continuing course of conduct that covered the entire period, that those could be tried with any one of the other sets that it did sever, and the state opted to try those with the felony murder charges, and that's the trial we had on those 6 counts. A lot of background there, I apologize. But in making that decision, the trial court pretty explicitly held that those 2 continuing course of conduct neglect charges did not fall under common scheme or plan. It specifically held in its order that there was not a distinctive design, or they were not signature crimes such that they would be probative of identity. The trial court specifically found that they did not make up a larger continuing plan or conspiracy. The trial court spent actually a lot of time in his order discussing that category of common scheme or plan, and found specifically that there was not an overarching goal joining those offenses. And then the trial court also found that they were not part of the same criminal transaction. So at that point, they should have been severed. There is not a carve-out for continuing conduct offenses under Rule 14b1.
So counsel, help me with this, because the procedural history is complex here, and I've got in front of me what the different counts are. Is it specifically that counts 5 and 6 should have been severed?
Yes, they were originally part of, in the indictment after the superseding indictment was handed down, they were counts 9 and 10.
Right.
The trial court renumbered them for trial, and they are 5 and 6 because the trial court did sever. I guess it would be the original 5 and 6, and then 7 and 8. And I'm sorry, that is confusing.
What was the time period with count 4 then? Count 4 was a neglect count also on the same dates, right? From September 28th through December 7th?
Count 4 was charged, well, the state's bill of particulars really helps with this.
Okay.
The count 4 was charged, as described in the bill of particulars, as an alternative count to count 3. And the date of offense there was December 7th. 7th,
right.
The other, counts 5 and 6, the continuing neglect charges, they range from September 28th, I think that's the right date in September, through and cite December 7th. So they do overlap there, and I think that is part of what gave rise later on to some of the jury's confusion about count 4 and correspondingly counts 5 and 6. At any rate, the trial court specifically held that they did not meet a common scheme or plan, but then just said that because of the continuing nature of the offense, they could be tried with the felony murder counts 1 through 4 with their predicate offenses. And we would just argue to this court that there is not a special exception for continuing offenses, or if there is, it's set forth in the statute. The continuing sexual abuse of a child statute actually sets forth that joinder happens under that statute, where there are continuous sexual abuse charges and then specific charges. And here in the aggravated child neglect statute, there is no corresponding joinder provision. And these should have been evaluated separately on their own as not meeting a continuing, common scheme or plan, and they should not have been joined with the offense here. And I think that the trial court's error there was compounded, and here I'm going to transition into the next issue.
But before you go there,
yes.
If you can help me get over a hurdle, and this is why I thank you for asking for argument, so we have the opportunity to ask these questions. How do counts 5 and 6 differ from count 4?
So count 4. Can I go by the state's argument and the state's bill of particulars? Because that's how it was set out for the jury. Well, the jury did not see the bill of particulars, but the state, in its closing, argued along those same lines. The jury, nonetheless, remained confused. Count 4 alleged the specific dire event that happened as proof demonstrated. There was some
On
back
December
and forth
7th?
about but yes, December 7th.
How do counts 5 and 6 then differ from each other?
Counts, I think count 5 rather, was a medical neglect charge, the neglect leading to serious bodily injury, and then count 6 was the torture count, especially heinous, atrocious, or cruel.
And in both, I guess in all 3 of those counts, 4, 5, and 6, they're all covering December 7th, right?
They are all covering December 7th.
Okay.
So I'm turning now to the trial court's failure to exclude some of the medical proof from Dr. Deering, and here we argued that there wasn't enough science. The trial court did not engage in a rigorous enough analysis in allowing this proof in, allowing it in as an inferential leap from a description, battered child syndrome, into its conclusions about how that syndrome could inform Dr. Deering about the cause of Jacoby's death and listing the manner of death as homicide. But most especially, at this point, we are concerned with the allowing Dr. Deering to testify about the contributing cause of death that he listed on the autopsy report and allowing that autopsy report into evidence. It is our position that that did not substantially help the jury and in fact confused them. It may have helped the state overcome a proof issue and allowed them to present their theory of how Jacoby died. But those words in the autopsy report and Dr. Deering's testimony about it did not substantially give the jury any insight into what those prior injuries did that would have let them be a contributory cause of death. He specifically said that they were non-lethal, and not one of them would have resulted in the death of this young man, but yet he also listed them as a cause of death. And it is our position that that was substantially confusing to the jury, giving rise again to what we see when the jury finally asks the two questions that it asks. So again, we have the consolidation error, this error in allowing the proof of Dr. Deering's sort of inferential leap that he makes for the jury, and then resulting in the jury not knowing which evidence it can consider for each of the counts. As to count 3, the jury, during deliberations, asked the trial court, does this charge refer to a specific context or event? Now, this is after the state had been fairly clear in its closing argument that it referred to the head injury on December 7th, but they nonetheless had the question. I think that that's meaningful, because I think that, to me, that means that despite the state being very clear about it, those other prior errors, the consolidation and the medical proof that was, in our position, fairly confusing, did in fact result in a jury that did not understand how, what proof went with what charges. Now, with regard to the first question, the parties agreed to provide a specific answer for that, and the answer that they gave was yes, it refers to the alleged head trauma that was incurred on December 7th, 2016. That comports with the state's theory that they presented in closing argument, and it was agreement. But later on, they asked basically the same question about count 4, which Judge Greenholz has asked about, and this is the aggravated neglect count that shares an overlapping date with counts 5 and count 6. In that case, they asked, we need clarification as to whether count 4 also refers specifically to the head trauma of 12/7/2016. Over defense objection, the trial court answered that question by writing back no and refer to the instructions. I think at that point, I mean, that was incorrect in terms of how the state tried to structure the facts and the charges in this case. And at that point, I think we cannot be assured of jury unanimity. We cannot be assured that the jury understood sort of its task at this point. And I think that, again, I'm saying this a lot, but I think that the errors in consolidation and the errors in allowing the court to hear, or the jury to hear about contributory cause of death for non-lethal injuries contributed ultimately to this error here.
Well, how does that error that's been conceded by the state, how does that impact, for example, the felony murder counts?
Well, I think certainly count 4 is one of the predicate offenses for
right.
count 2 felony murder,
right.
And it would impact that one. I think those right. counts rise and fall together.
What about count 1, though, that's based upon the abuse?
Count 1 is based on the abuse charged in count 3. They had a question about that. That question was answered appropriately, but at the same time, I think that question reveals a good deal of confusion generally about how to line up the evidence that they heard with the charges that they were.
With respect to the neglect counts, maybe, but what about with respect to the abuse counts? So I understood the argument when I asked about the concession earlier. I understood that the argument was that error impacts the other counts as well. How does it impact, for example, the felony murder count on 1, which is based upon the child abuse?
Yes, and that count 1 and count 3, those go together. I would just say that because they also had a question about count 3,
right.
that they didn't quite understand the boundaries between the charges and the facts that they heard.
But after they received an admittedly appropriate answer, would the presumption be that they did understand at that point?
They had.
All right, so are counts 1 and 3 sufficient?
Again, I think that the fact that they had questions and compounded by the earlier errors that I discussed, I think that there is enough evidence to demonstrate that the verdict as a whole, the integrity of the verdict of the whole as a whole is undermined. I think obviously it's stronger as to the neglect counts and the corresponding felony murder counts, but I don't think that you can necessarily discount the fact that this was on whole a confused jury based on the prior errors that we discussed.
Okay.
I think that it's not just the erroneous answer, but the fact that they had those questions, I think, is what I'm trying to say there. That and when it did get the improper erroneous answer, that just dissolved the boundaries between the factual underpinnings of each of the offenses. We are asking here for the trial, for this court to remand Ms. Gardner's case for a new trial. We're also asking, and the state conceded this point as well, that it be remanded for a new sentencing hearing on the Wilkerson factors. The trial court did not conduct a proper analysis under that, which this court and the Supreme Court has held as the most subjective of consecutive sentencing factors, and requires a higher burden of information in the record from the trial court. So if there are not any further questions, thank you very much.
General?
Good morning. May it please the court, Lacey Wilbur on behalf of the state. Your Honors, the trial court erred in its response to count 4, and it also erred by not doing the Wilkerson findings, and we ask that you remand for a new trial on count 4 and for a resentencing hearing. But with respect to all the other...
How does the remand on count 4 affect count 2?
I don't think it does at all.
That was not the underlying felony for count 2?
It is the underlying felony for count 2, but the death is the count 2 that was related to the blow inflicted on 12/7. I'm sorry.
No, I'm sorry, excuse me. I mean, but it's a death that occurs during the commission of a felony.
Yes.
And so if we're retrying whether there was a felony, does that not affect, that doesn't affect count 2, in other words?
I don't believe that it does. It's still there because we have the death. And again, we're only asking the remand because, not because of sufficiency, we're asking because of the judge's erroneous answer to a jury question. So there is sufficiency on count 4, and we briefed that in our brief. And so we would argue that count 4 and count 2, there's sufficient evidence to support their convictions and to uphold them on appeal. And I would like to thank opposing counsel for setting this out so beautifully, so I don't have to do it as much. And so your honors understand the counts. And there was no error when the judge partially denied and partially granted the motion to sever the offenses. Judge Greenholtz, as you noted, the counts 5 and 6 that were originally counts 9 and 10, they alleged conduct ranging from 9/28 through 12/7, which was when the fatal blow was inflicted.
So why is the stuff that happened between 9/28 and 12/6 relevant to a case that happened, an event that happened on 12/7?
I think we're kind of hopping around between issues, kind of like the council did, but it's because.
I mean, that's the severance and joinder issue. I mean, they under the rule, they have to have some connection.
They do have a connection, and it is.
But what is the stuff? How is the stuff from 9/28 to 12/6 related at all to what took place on 12/7? How is that connected? How do I get to talk about all the stuff that happened between 9 and 12 in a case on 12/7 only?
And again, this is going to go down to battered child syndrome. And if you only have the evidence of a child died from blunt force trauma, Dr. Deering testified, I would have only been able to say the cause of death was unknown. But because there is the existence of battered child syndrome, it opens up for you to look at all these other things. And when you look at Collective Exhibit 2, the photos of the injuries on this child, I think you'll have the same reaction I did. And what Detective Vaughn, who had done 200 to 300 child abuse cases, she said she was in complete shock when she saw the child's body in the hospital. And it's because, and I don't want to interrupt Your Honor, but again, it's because we have all these injuries and neglect of not taking him to seek medical attention for the horrific burns on his hands.
And I don't want to minimize what took place. That's not my point of my question. But if the medical examiner said that all of these other abuse and neglect issues were non-lethal,
Yes.
and that the lethal blow was on 12/7. Well, again, how is all of that? I mean, that seems highly prejudicial to say, hey, all this stuff happened that was non-lethal and was horrible, but it happened, but we're charging with felony murder for a blow, neglect, and an abuse that took place on this date. So why is all of this relevant?
Again, it's battered child syndrome.
But how does it stage? But that's not. There's not a charge of battered. It's not like the continuation of the sexual
No.
child sex abuse, where that clearly comes in. You can charge 1, 2, 3 incidents, and then charge, hey, by the way, all this stuff happened. We don't have that in this case. So how does that pass the test when they file a request for severance?
Again, it's battered child syndrome.
Okay, where in the rule does battered child syndrome say we don't have to sever?
It does not, but it
Okay.
is part of the
So
same criminal transaction.
what part of the rule allows for that to happen?
I would say it's that you can say it's the
It's
same.
a signature crime?
No, same
Okay.
criminal transaction.
Same criminal transaction. So what took place 3 months ahead or during a 3-month period that was non-lethal resulted in a lethal blow, and therefore that's all one transaction?
We would argue yes, but if Your Honor is very much against it, which I sense that you are.
Well, I'm
that-
just trying, no, I don't, I'm just trying to
That
figure
is-
out how this works
That
because.
is our position on that. And it's inartfully worded in the judge's order, partially granting,
Well, I
partially
mean,
denying.
didn't the trial court, though, make a finding that it was not part of the same criminal transaction? Did it not?
No, I don't.
I thought I understood, that's what I understood from the record. I thought I heard your friend
I
on
know
the
he
other
said it wasn't a
side.
signature crime.
Yeah,
Correct.
I
He did
thought I
not say
heard
it was a signature
Your
crime.
friend on the other side suggest also that there was a finding that this was not part of the same criminal transaction, even though it's
He
a
did,
continuing
he
offense.
found that it was not common scheme or plan, but not that it was not part of the same criminal transaction. And I think that's because, as he worded it in his, it occurred during this period. It's an ongoing
If he
period.
found that it is not part of a common scheme or plan, necessarily, he must have found that it was not a continuing criminal transaction, right?
I don't,
I mean, because the latter, I mean, is part of the definition of the former.
I see your point, Your Honor.
So
But-
if that's the case, and we're not changing theories coming up on appeal,
No, no.
back to Judge Dyer's question, how is it relevant
How is it relevant
to the death?
to the death?
Yes, ma'am.
It goes towards what happened to this child, and
We'll put on the table that what happened to this child as revealed in that exhibit is outrageous. I'll put that on the table. We all see that. Back to Judge Dyer's question, though. Can you help us understand, please?
I don't think I'm going to give you a satisfactory answer. So what I will now say is that even if it were error, it would be harmless, because Dr. Deering at trial made it very clear. He said all of these injuries, the battered rib, the bruised rib, no, the broken ribs, broken nose, black eye, all of these injuries, the horrible burns to the child, and he also had blisters that had popped on every single one of his toes. He said none of this caused the child's death. So even if this should have been in a separate trial, the fact that they were tried together, it was harmless error, because there was no evidence saying that evidence.
Okay, let's move off the horrific facts of this case, and let's just move to a hypothetical to make it easier, maybe, or less painful. So, defendant is charged with a murder, and he has numerous assaults that take place during drug transactions, because he's a drug dealer, for over a 3-month period, and then there's a murder. Does all this stuff come in?
No, Your Honor.
Okay. So he has assaultive behavior, which is not related to the murder. It wasn't what caused the death. He was a drug dealer, has nothing to do with the murder, other than maybe the murder occurred during a drug transaction, let's say. So you admit none of that comes in.
Yes, Your Honor.
So why is this different?
I think it's because of,
So we get to talk about all of his the defendant's horrific actions towards this poor child that didn't cause the death and that he's not being charged with as a crime, to talk about the death of this child.
I understand. I understand your concern. I completely understand your concern.
Okay.
Is there an answer to the concern?
I don't think there's,
I mean, you
I
said-
don't
you
think I
said-
can give you a
in
satisfactory.
In fairness, you
Yeah.
said there's not a satisfactory answer, and I appreciate the candor. Is there an unsatisfactory answer? I mean, is there an answer to it?
About why it came in,
Yes,
or what, I think it was just because the indictment had a range that encompassed 12-7, which was counts 3 and 4, that the judge said it can come in because that happened during that range.
Okay, and so the argument then is that it's harmless because there's, what, overwhelming evidence of the cause of death? And that
Yes.
the inherently prejudicial nature of this evidence would not have affected the jury's evaluation of the evidence of the cause of death?
There is no way that Dr. Deering could have provided testimony about the death without talking about battered child syndrome, because he said, otherwise, if I couldn't talk about that, I would have had to have said that the death was unknown or undefined. But because I have all of these other injuries, and he called them a constellation
What
of
was
injuries.
what was the lethal reason for the, what was his what did he say was the lethal blow? That might be my right
The
term. but-
cause of death?
Yeah.
The cause of death was anoxic hypoxic encephalopathy, which means the brain was not getting oxygen, and he died of brain death.
Okay.
And his mother withdrew
So he
life
can,
support.
he can testify to a cause of death.
He could testify that the child suffered a blow to the head, but was it accidental? Was it intentional? And when you bring in these other injuries through battered child syndrome, which this court and our Tennessee Supreme Court has allowed since 1977, you get to see the constellation of injuries that allowed Dr. Deering to say this was a homicide. This was felony murder.
Like you say, General, isn't that a long-standing practice for forensic pathologists, both in this state and across the nation? In some sense, wouldn't Dr. Deering have been putting his head in the sand to ignore the injuries that had been inflicted upon this child and to say, I don't know what happened.
Yes, Your
This is
Honor.
undetermined manner of death here.
And I think it would cause a lot of jury questions when they see the photographs of the child with all of the bruises, and then all they're talking about is a head injury. So yes, it's been, the article on battered child syndrome came out in 1962. The earliest case in Tennessee I can find is 1977. I cited 12 cases in my brief where pathologists listed battered child syndrome as the cause of death. So that is very widely accepted in this state, as you know.
It's one thing to allow the medical examiner to testify as, when I was looking at the body, I noticed healing ribs, I noticed this, I noticed that. Okay. It's another thing to add a lengthy set of charges that actually had, in one sense, nothing to do with the death. I mean, we get that a lot of times where it's just one count, let's say, of a child, of felony murder based on child abuse. And in that, the medical examiner testifies, well, in conducting my investigation, I noticed, bruising on the back, I noticed healing bruising, healing this, healing that, which clearly the implication is that there's an abuse situation that was ongoing. It's another thing to charge all those crimes at the same time. That's my point.
I completely understand your point. I understand your concern, and I would just again posit that any error was harmless because of the overwhelming evidence.
Okay, so any error is harmless except for the fact that the jury has two questions because they're confused about what they're supposed to do.
We have two jury questions just on counts 3 and 4, which were the blow to the head inflicted on 12-7. We don't have questions on any of the other counts. And again, as Judge Greenholz noted, the judge correctly answered count 3. So count 3 is still there. It did not infect count 1 or count 2. They're still solid. They're still good. The only error is in the answer to count 4, where the judge basically was like, pick and choose. And that was error, and we can see that was.
May I pose another analogy to you, General? I know Judge Dyer mentioned the example of a drug dealer who had committed prior assaults. What about the example of a husband who beats his wife every day over a 3-month period and eventually one day goes over the top and strangles her to death? Would proof of that prior abuse be admissible to demonstrate that he had a settled intent and purpose to cause her death?
Yes, Your Honor, and I'm sure there are several cases, I can't think of any off the top of my head, but yes, I'm sure there are already several cases out there that have done that exact same thing, and this court has affirmed.
There are
And
several cases that do that in the context of Rule 404B evidence.
Yes.
To take Judge Hickson's hypothetical maybe one step further, would it be proper to try the previous instances of abuse against the spouse in the same trial as the homicide?
I think so, yes.
If the trial court makes a finding that there's no common scheme or plan?
That would make it harder because
That's
it
what
was
happened here,
clearly
though, right?
his intent, yes.
That's
And
what
again,
happened here, right?
yes, again.
And that's, you've answered it 1,000 times the best you can, I know, but that's my point. I mean, there is lots of truth behind every question that Judge Hickson's asking, but the same is true of Judge Greenholt's questions, is you still have to make a finding under the rules concerning severance and joinder if you're gonna try them all together. You just don't have, I don't think you really have one here, other than I'm going to do this. You don't have a factual legal analysis basis. But you basically don't even have one here. He just says, we're gonna do this. And that's where I agree with both of them in a sense, but that's the issue I'm having with this. And I know you said there's not gonna be an answer I like, but I appreciate you trying.
No, but again, I just want to ask this court, if you do find that that was error, it is harmless, because all of that evidence would have come in due to battered child syndrome. So any error would be harmless, and this
So I understand the relevance, and I'm just trying to figure out where the argument is I'm hearing the relevance there, is that it's one thing to talk about the blow on 12-7. The expert can't make an analysis about the cause of death being the blow without also having the evidence from battered child syndrome. And you're right, I mean, Durantis itself recognized battered child syndrome as an area of expertise, so I understand that. So we're talking about an intent issue
Yes, Your Honor.
here, okay, all right.
I think I've covered the battered child syndrome to death, and so I won't argue that. And as I argued earlier, count 4, yes, that should be remanded for a new trial, but that did not infect count 3 because the court properly answered count 3. I'll rely on my brief for the remainder of the issues if the court has no more questions.
So that I'm clear before you step down, once again, thank you for participating in argument. State concedes that there's error in count 4 that should be remanded for a new trial. The state, irrespective of that, also believes that it should be remanded for a new sentencing because of the failure to make Wilkerson findings.
Yes, Your Honor.
Correct, okay. All right,
I was
thank
just about to say that, so thank you for
Yeah, thank
saying
you.
that for
Yeah.
me. And then we ask that you affirm in all other respects.
you. Okay, thank you.
Thank you.
Thanks, counsel.
Thank you. I will not take up much time on rebuttal. I will just clarify that the trial court did make a specific finding that these offenses were not part of the same criminal transaction. That's on page 235 of the technical record. And the trial court also noted at the bottom of that page that what the trial judge called a paradox, that achieves neither, given the nature of these offenses as they were laid out and charged, that achieves neither judicial economy, which is something that the joinder and consolidation rules strive for, nor does it insulate a defendant from having prior conduct raised at trial as a charged offense.
So just to help me, assuming without deciding that there is a severance issue, what's the remedy?
I think the remedy would be new trials on both sets of offenses. I think this goes back for a new trial with severed accounts. Another thing that
Okay,
I'd like to
that
point
does
out,
not affect count 1 or 3, is that correct?
I think that it does, because again, they were charged as the sets of offenses that trial counsel sought to sever were counts 1 through 4 as one set, because counts 1 and 3 were improperly consolidated here as well with counts 5 and 6. So I think that a new trial would contemplate a new trial on both sets of offenses as severed.
Your friend on the other side argues that the error would be harmless because there's overwhelming evidence otherwise supporting the verdict. What's your response to that?
Well, I think one of the interesting things that happened in the pretrial litigation in this case is that before the superseding indictment was handed down, trial counsel had filed a motion to exclude the prior injury evidence, like the examples you gave, Judge Hickson, where it was not charged conduct. And the trial court made rulings there that would have permitted it, but the trial judge made those rulings based on 402 and 403 because there was no allegation as to who caused the prior injury. So under DuBose, that had to be evaluated under Rule 403. 402 and 403, a far less protective standard. So again, when the trial court denied severance here, it never then turned and made a 404B ruling as to any of this evidence. So I would submit that harmlessness can't really be set out yet because we haven't even had that full hearing yet on what would have come in. We had some, you look like one answer.
No, go ahead.
Oh,
Finish your answer.
we had some injuries described that from the proof looked like they took place outside of the offense dates in the charged conduct, September 28th through December 7th. We had other ones that could have been sussed out more in pretrial litigation if it was going to be looked at under Rule 404B, which does require a clear, convincing standard. So I guess my one response to you, Judge Greenholz, would be that just we haven't had that hearing yet because of some of the ways things came up in pretrial litigation.
So if we were going to agree with you on remand, then I'll let you sit down. If we were going to remand it, and there were going to be new trials, back to Judge Hickson's question, the medical examiner still would be able to testify about when I examined the child, I noticed healing here and there was bruising here in order to reach a cause of death, correct?
Well, we would still point you to the error that we think the trial judge made in allowing some of that to come in as non-lethal contributory cause of death. But yes, I think that like in any case where there is other evidence that
The battered child syndrome issue.
It could be contested in
So the
court
state-
under the
this-
appropriate standards.
The state, though, argues that that evidence is relevant to intent and that the non-lethal contributory causes were what separated an accident from something more nefarious. So why wouldn't that be relevant?
Well, depending on how the litigation came up, and this would be a new setting under new standards if it's charged conduct. But one thing that was pointed out by trial counsel repeatedly, I think that he even filed a renewed motion to exclude prior injury evidence. It's because trial hadn't happened yet, and Latonia Gardner had not yet asserted accident as a defense. And there was some indication from trial counsel that might not be relevant if she didn't assert that. So that hadn't happened yet. He asked for a ruling on that and was denied. And then obviously, as I think the briefs probably show, that did turn out to be a defense at trial, but it didn't necessarily have to be had the trial court ruled appropriately as to the prior injury evidence.
Thank you, counsel.
Thank you very much.
Thank you.
You good? Call the next case.
State of Tennessee versus Andre Perkins.